My name is Seth Bloom. I'm the Senior Director of Attorney Services here at LevelSet. This is part of our webinar series where we have lawyers come on and talk to us about different issues within the construction industry, especially getting paid quicker. Today we're ecstatic to have Joseph Brophy from Jennings, Haug, and Cunningham. And today's topic is going to be Arizona mechanics lien law and the landmines. So I will go ahead and let Joe take over. If you have any questions, right now is a great time to ask them. So please post your questions and I'll interrupt Joe and we'll see if he has an answer for us. So thank you so much for doing this, Joe. We look forward to it and it's all you.
Thank you, Seth. As Seth mentioned, my name is Joe Brophy. I'm a partner at Jennings, Haug, and Cunningham. It's a law firm here in Phoenix, Arizona. I'm also a member of the executive committee of the Arizona State Bar Construction Section. And I also moonlight as one of the experts here that sometimes answers questions for the customers and contractors that use LevelSet. My firm, Jennings, Haug, and Cunningham, was founded in 1937. We do pretty much all kinds of litigation, anything you can think of, but for many years our bread and butter has been both construction and surety law. Today I'm going to run down some of the common mistakes and landmines that contractors run into when trying to perfect and record mechanics liens. The discussion and materials here today are a general outline overview of both the statutes and the applicable law. The materials, particularly because of the short time frame, are generalized and they are not a substitute for legal counsel for specific situations. So with that in mind, if we could go ahead and hit slide 2. A valid mechanics lien is just simply a non-perfected interest in real property or improvements for which work is done. The lien only helps to ensure payment. It's a common misconception that if you record a mechanics lien that you're definitely going to get paid. That's simply not true. It puts a lien on the property, but it's, number one, there's issues of who's in first position as far as liens go. Sometimes there's other creditors out there. And the lien itself is not self-executing. You have to go through certain steps to properly record one. And in fact, in a lot of ways, mechanics liens, as far as security for payment, are sort of overrated. You have to have equity in the property, the owner does, for the lien to attach to. Very often you're going to have a purchase or a construction loan that is secured by a first position lien on the property. So the question is, even if you have a valid mechanics lien, after you take the value of the property, subtract that from the amount of the loan, is there any equity left over for you to get paid? It's better to have a lien than not, but you need to manage your expectations as to what that means, assuming that you do everything correctly. Next slide, please. Mechanics liens have two purposes. The first one being to protect the people that improved the value of real property. Construction is a good thing. The legislature wants to encourage this type of economic activity, so they passed the mechanics lien statute because it makes doing construction work a little bit less risky, and in theory, that's good for all of us. Something that a lot of contractors overlook, though, is that there's two sides to that coin. The other side of the coin is the statutes are there for the protection of the owners. And this is critical to some of the landmines that we're going to discuss today. A mechanics lien is an involuntary lien. The property owner didn't agree to have their property lien the way that you agree to have a mortgage put on your house, or the way you agree for the finance company to take a security interest in your vehicle. And it's not like a judgment lien where the owner has been given due process, and a court decided that they owed money. It's an involuntary lien, and because of that, there's a lot of hoops that the contractor who wants to assert this kind of lien against the property has to jump through. And the purpose of those hoops are to protect the owner. So basically the legislature and the courts say, tell you what, to give you additional security for payment, we're going to allow this special type of involuntary lien. But the caveat is you better follow the steps pretty much to the letter, otherwise the lien's going to be invalid, because we really don't like imposing involuntary liens on real property unless there's been due process. Next slide, please. So part of the facilitation of the protection of the landowners is the preliminary 20-day notice. That has certain requirements, and it also has certain requirements that you record a lien within a certain amount of time. And we'll get into the reasons for that here shortly. Next slide, please. I just have to get this out of the way. Question, who must serve a preliminary 20-day notice? Next slide, the answer. Everyone. If you want a mechanics lien, you have to serve a preliminary 20-day notice. If you don't serve a preliminary 20-day notice in Arizona, you are not going to have a mechanics lien. And again, the preliminary 20-day notice is there to protect the owner, to let him know that there is somebody out there asserting a lien against their property, and it gives them the opportunity to investigate and see what the story is with that. Next slide, please. You have to serve the preliminary 20-day notice on an owner or the reputed owner, the general contractor, the construction lender, or the reputed lender. If you think somebody, even if you think that they have a loan and you're not sure, you have to serve them. And the entity with whom the contractor has a contract with. So that would be, if you're a subcontractor, that would be the general contractor. So everybody gets a copy of the preliminary 20-day notice. Next slide, please.
Joe, we have a question coming in. I could probably answer it too, but someone asked, is this seminar only for Arizona law, or does it apply in all states? And I guess, you could answer that, but basically some of the concepts are similar, but this is specifically for Arizona. Would you agree with that, or?
Yes, but mechanics lien statutes in all states serve the same purpose, so they all follow the same general rules. But yeah, I mean, there's, for example, there's states where your preliminary notice is a 40-day notice, not a 20-day notice. So yeah, the specifics are Arizona.
Right. So if you are filing a lien or need lien advice in another state, you should post something on the Expert Center and the Attorney Network, or consult with a lawyer in your state.
Right. All right, the contents of a preliminary 20-day notice are listed in the statute. You have to hit each one of these for the notice to be valid. General description of the labor, an estimate of the total price, and the items to be furnished, name and address of the claimant, that's the contractor asserting the lien, and the name of the person who you contracted for, and the legal description of the property, subdivision, plat, street address. We're going to get into this here shortly. The purpose of all of this is to give the owner notice of exactly what the potential lien claim, what the nature of it is. It's different than a mechanics lien where you have to have more specific information. We'll get into that shortly, but it's important not to get the 20-day notice confused with the actual notice and claim of lien, because if you treat them the same way and you put the same information in there, you're going to screw up your lien. But again, all of these things in the 20-day notice, just there to give the owner notice of the potential lien claim out there. So if this comes as a shock to the owner, they are able to investigate. Okay, here's the name of the claimant. I've never even heard of this contractor before. I'm going to call them and ask them why I'm getting a preliminary notice, and so forth. It gives the owner enough information to start asking questions about why is somebody sending me, or why is there a potential mechanics lien out there. Next slide, please. The preliminary 20-day notice has to contain certain magic language, and it has to be in bold. This comes right out of the mechanics lien statute. It has to be on every single preliminary 20-day notice. I would definitely recommend just copying and pasting it. Next slide. In addition, the statute says that the language that is in the preliminary 20-day notice, the specified language, has to be in type just as large as any other on the notice. So you can't, what that's basically saying is when you put in the magic words that have to come out of the statute, you put them in bold and you don't make them small. There's no fine print on this. And it's this type of stuff that people get into trouble over and that lawyers like to use to try to, if they're representing an owner, try to get the owner out of payment. I don't think that in Arizona we've litigated what happens if certain specific language is not in bold, but I don't think you want to be the one to find out. And I have seen fights over the font on the magic words in a preliminary 20-day notice. These things happen, and they are both unfortunate and expensive. So follow the statute as close to the letter as you possibly can. Next slide, please. Service or preliminary 20-day notice. It should be served the second that you start work on the site. Typically, it's too late if you wait till you're not paid, and you can send the letter by registered or certified mail. Here is a little pro tip. People think that they're being extra thorough if you send the mail certified, return receipt requested. Don't do it. Because if and when the owner denies ever receiving the preliminary 20-day notice, and they say, I never got it, and let's say that the post office delivers it, that nobody signs off on the return receipt requested, and then now you've just given the owner something to dispute that you ever actually sent it because you tried to get a return receipt and for whatever reason the post office doesn't have it. You just potentially caused yourself a problem. Whereas if you just do what the statute says and send the preliminary 20-day notice, certified mail, get the proof of mailing from the post office, you're golden. It doesn't matter whether or not the owner receives the notice. It matters whether it was mailed. And so just get the proof that you mailed it and then be done with it. Resist the temptation to say, well, if I get their signature, then my service is going to be even better. That's true, but it's also not necessary at all. Next slide, please. The statute for the preliminary 20-day notice says the form provided for in the statute must be, quote, substantially, unquote, followed, which raises the issue, what does substantially mean? And the answer is nobody knows, which is what lawyers fight over. How close do you need to be? The answer is as close as possible. There's case law on it that addresses specific circumstances. Well, this is substantially compliant, this is not, but those factors are all there to allow the list of items that go into a preliminary 20-day notice, they're all there to allow the owner to investigate what the source of the claim is and the reason for it. And so if you're missing any of those, you definitely are not substantially compliant. You don't get, well, 3 out of 4 ain't bad. It's, well, I have 4 out of 4, and one of them maybe isn't quite what the statute says, but it's pretty close. So substantial compliance, you want to be as close as possible, because again, if you don't have a valid preliminary notice, you do not have a lien. If you don't have the statutorily mandated language, you do not have a lien. Next slide. So how do you get this information? Sometimes you don't have a description of the property. or you're not sure. For example, let's say that you are delivering materials to a case once with it was a college dormitory up in Northern Arizona University. And it's this huge sprawling complex. And so the question is, where exactly did we deliver our materials to? Because there's actually multiple addresses there. And so if there's some information that is supposed to be in the preliminary 20-day notice and you don't have it, under the statute, you can write a letter to the owner requesting all of the information in the preliminary 20-day notice, and they're obligated to send you a response providing that information within 10 days. If they don't, then they basically waived any defense about if you have something wrong in your preliminary 20-day notice because they had an obligation to provide it and they refused to. So if there's a screw up on the 20-day notice that results from the owner's failure to comply with the statute, then they no longer have those defenses available to them. You'll notice that the time frame on this fits very nicely with the preliminary 20-day. You have the notice makes the lien valid for work 20 days prior to the notice going forward. The request for information to the owner has to be responded to in 10 days. All this preliminary notice stuff works better if you do it at the beginning of the project. If you're scrambling in the middle or at the end of the project trying to get this stuff while the clock is ticking, and additional work is being done when you don't have your 20-day notice sent, it's the lien is going to be worth a lot less or maybe useless. So that is our quick and dirty overview, and let's get into the big mistakes that we see, and we'll just blow through these real quick. Next slide. These are the big three. Failure to provide a preliminary 20-day notice, failure to amend, and failure to mail the preliminary 20-day notice. These are sort of the big three that we see that ruin people's mechanics liens claims. Next slide. We went over this briefly. When you send the 20-day notice, you have to mail it. You have to get your proof of mailing, or in an affidavit of mailing. So the proof of mailing is what is the document that comes from the little slip. It's usually green and white. That comes from the post office. So you mail the 20-day notice, you get the proof of mailing, and then you'll later have to do an affidavit of mailing saying I, contractor, mailed, certified mail on whatever date, the preliminary 20-day notice to this person. All three of those things need to go on a mechanics lien in Arizona. Otherwise, you're not going to have a valid lien. As I said before, everybody has to mail a preliminary 20-day notice if you want a mechanics lien. It should be done the first day you start on the job. It's called a 20-day notice because it goes any work done 20 days prior to the notice being sent and going forward, that can all be secured by the lien. If you don't mail one, you don't have a mechanics lien. If you wake up you're in the middle of your work and you haven't mailed the preliminary 20-day notice, if you're still working, send it anyway, because you'll at least be able to have, let's say you're halfway done, you'll have roughly half your work secured by a lien. The first half of the project won't be secured by a lien, but it's not the end of the world. If you send a preliminary 20-day notice at the end of the job, depending on how long you've been working on the job, you're probably out of luck, because it's only going to go back 20 days, and most of your work will not be, the amount owed for your work will simply not be secured by the lien. So just make it a habit. Once you step foot on that project, 20-day notice goes out. Next slide. The next big one is failure to amend a preliminary notice. So you send a preliminary 20-day notice out. It's usually going to be, you don't really know how much you're going to be owed when it comes time for the mechanics lien to get recorded if you have to do that. So you'll typically put in the contract price for the amount owed. So if you have, let's say, $1 million contract, you'll put $1 million. Well, as the project goes on, that presumably as you get progress payments, that amount is going to go down. If the amount owed goes down by more than 20%, you just have to send an amended preliminary 20-day notice with the new amount. And again, the preliminary notice, this is all about letting the owner know how much encumbrance is he looking at on his property. So, or alternatively, let's say that you've had a bunch of big change orders and the general contractor is just going to town on this stuff. Well, the owner needs to know the $1 million preliminary 20-day notice I sent you is, well, now it's a $2 million claim because there's been so much more work done during the course and scope of the project. So make sure that you amend your preliminary 20-day notice if it's more than 20% above or below what the original amount was. Next slide. Done a lot of talking about preliminary 20-day notices. One of the other big mistakes we see is the failure to obtain a correct legal description, not for the preliminary 20-day notice, but for the actual lien. In a preliminary 20-day notice, you're just giving notice to the owner about, here's the property that I have a potential claim against. So you can use something like a street address. But the notice and claim of lien is an actual lien on property. When it comes to that, you need an accurate legal description that spells out exactly what the lien is on. And if you screw it up, you're going to have a problem because this is land. We take land seriously here in this country. So you don't need a legal description. You can have one in the preliminary 20-day notice. You do need an accurate legal description in an actual mechanics lien. You cannot refer to a tax assessor parcel number, parcel number whatever for the house. You cannot refer to a street address. You are allowed to refer, let's say that there's a deed of trust or a mortgage on the property. You are allowed under the statute to refer to the property described in that deed of trust on file with the Maricopa County Recorder's Office, document number, whatever, and then that has a correct legal description. You can do that. But there's some counties here in Arizona where the county recorder will make you spell out the legal description. So appreciate the difference. When you're actually recording the lien, you need a real life, honest to goodness legal description somewhere so that there is a description of exactly what property is being liened, which is different than a preliminary 20-day notice for which the description of the property is a lot less stringent. Next slide, please. Failure to recognize project completion. Okay. In Arizona, you have 120 days to record your mechanics lien after the project is complete, or you have 60 days after completion if the completion is done by a recorded notice of completion. So that raises the issue, what the heck does completion mean? And for this, there's statutory definitions of it. For this, the only thing you need to take away from this for a seminar as short as today is just because you think the job is done or it's not done, if there's additional work, let's say you have punch list work going on, just because there's still work going on does not mean that the project is not complete for purposes of recording a mechanics lien. So you need to pay attention to that and find out whether there's been a notice of completion recorded or whether there's been a certificate of occupancy issued. Sometimes that'll signal completion. But the main thing to think about with this is there is no penalty for recording a mechanics lien early. Sometimes owners get upset about that, but the mechanics lien is going to go away if they pay. So no harm, no foul, just pay your bills. So don't be hesitant or afraid to just record a mechanics lien early, and then you don't have to worry about this stuff. Next slide, please. Failure to apportion on multi-structure projects. We just got done talking about legal description. So let's say you're doing a subdivision or even worse, a condominium. Those are owned by individual people or they're able to be sold by individual people to individual people. So to the extent that you can, if you're working on a subdivision and you only leaned, you only worked on certain parcels, then those are the only parcels that you have a lien against. You only have a lien on property that you improved. And so if you do have something like that, you need to apportion your lien. You can't just record a blanket lien all over a subdivision. A possible exception to that is if you're just delivering materials to a project like a multifamily, apartment complex, a college dormitory, and you're dropping off whatever, copper piping or whatever you're supplying. You have absolutely no idea where it went because you're not actually working on the project. You're just a supplier. You may be able to get a blanket lien under those circumstances. A good way to cover your butt is to go ahead and send a request for information to the owner and say, okay, where did all my materials go? They're not going to be able to answer it, but at least you're able to say, I asked, they didn't provide it. But just remember, if you're on multi-structure projects, you have to apportion your mechanics lien to the individual properties that you worked on. Next slide. Failure to recognize owner occupied in Arizona. You can have a mechanics lien even though you don't have a written contract. Oral contracts are enforceable in this state, most other states as well. But if it's an owner-occupied residential property, somebody's main home, and the contract is with a person, the contract has to be in writing. Otherwise, you can't assert a mechanics lien. Next slide. Let's go back one. Another big, the failure to recognize the difference between a landlord and a tenant. If the project owner is a tenant who's doing tenant improvements, the lien is only against the leasehold interest. You don't have a lien against the property. The best example of this is, let's say you're doing work on a restaurant, but the restaurant's just the tenant. When you foreclose your mechanics lien, you're going to be the owner of a bunch of bar stools and tables. You are not going to foreclose on the property. The exception to that is if the owner is the one that ordered the improvements or required them, then you can. You can foreclose and attach to the actual property. Next slide. Failure to record. That's pretty self-explanatory. You need to record within 120 days after project completion. Next slide. Failure to serve. Remember, all this stuff, all these protections, these are all about notice. You have to serve the lien on the property's owner when it's done. What's the time frame on this? It's just a reasonable time, whatever that means. Do it promptly. I'm sure you can probably get away with a couple, 2-3 weeks, but don't test the system. Once it's recorded, mail that sucker to the project owner so that they know that there is a lien on the property. Next slide. Failure to timely sue to foreclose. Once you record the mechanics lien, you have 6 months to sue to foreclose. Again, they don't like clouding people's title to property in this way. When nothing has been adjudicated and they didn't agree to it. So you have a very short timeline. 6 months is a millisecond in legal terms. 6 months to file your suit to foreclose. Otherwise, the lien is invalid. When the lawsuit's filed, make sure you file a lis pendens, putting everyone on notice that there's a pending foreclosure suit. Next slide. We just went over that, the notice of pendency of action. Next slide. Failure to timely add a surety. If an owner does not want people recording mechanics liens on their property, they can get a discharge bond or a mechanics lien bond where it says, okay, we're going to have a surety put up a pot of money, and if you don't get paid, you don't have to encumber my property, but there's this big pot of money out here called the surety, and they'll be there to pay. Now that sounds great. It's better to have cash than have foreclosure, but sureties, just like insurance companies, don't just go around writing checks because they love you. So if you do have to sue on a bond because that took the place of a mechanics lien, you need to add the surety. And you need to do so in a timely manner. So something to think about. Just because there's a bond doesn't mean you automatically get the money. You have to sue the surety in addition to the owner. So it's a subtle difference where you would only sue the owner in a regular mechanics lien action. if there is a bond, you got to sue the surety. There's time limits on that. Next slide. All right, that's it. We're 6 minutes late, and I apologize for the technical difficulties in getting started, but if anybody has any questions, I'll be happy to answer them.
Yeah, no problem, Joe. We've had this before. You know, everyone's getting used to using
Yeah.
Zoom and all this video conferencing stuff. But if there's any questions, does anyone have any questions? I know it's been a particularly quiet one, but appreciate you putting your time in both in this webinar as well as answering questions on our expert center. If anyone out there has construction legal questions in Arizona, please post those questions on the Attorney Network where you can ask a question. And also you can call Joseph and his law firm directly and they'll answer and help you any way they can. So again, thank you, Joseph, so much for your time.
All right.
We really appreciate it.
Thank you, guys. Appreciate it.